purely on IP talk. All right. So this is the 5th chapter of the IP talk tonight. Wait. Wait. Okay. Let me just adjust it. All right. Okay. First thing before we start, I had to put a disclaimer here, just to tell you in brief that nothing in this video shall be used as your reference, advice, and you shall not rely on any information here when you make any decisions, which is so great. And I advise you to consult your lawyer. And if you do not have a lawyer, call me up. I will get you an attorney, all right, a fully qualified attorney to consult you to tailor for your specific, problems. Okay. Tonight we are just trying our best to tell you the case law. Okay, the reported cases. So please, even though there might be any, omissions, inaccuracy, or maybe not up to date or whatsoever, we disclaim all liabilities, okay, from these seminars, and please understand that. Thank you very much. Let's begin. So the first case that I want to talk about for tonight will be the famous case in the early 2010, okay, in the 2009. Yeah, this is a very famous case. It's called McCurry's and McDonald's. It's a Court of Appeal case. All right. Today I'm going to discuss on this case, and this is a Court of Appeal case, a decisions by the Court of Appeal, Malaysia. So let me just introduce in very brief. Okay, the plaintiff in this case we all know is McDonald's. When I say plaintiff, means the plaintiff at the High Court. Of course, this is appeal court. So in the appeal court, we normally refer the person who appeal will be the appellate. So in this case, the defendant is the appellant, and the plaintiff is the respondent. But for the sake of my explanation tonight, I just refer them as plaintiff and defendants. So the plaintiff in this case will be McDonald's, the defendant will be the McCurry. Okay, let me just tell you something about the facts in brief. All right. Now, you see, the plaintiff, McDonald's, was a fast food franchisor. Everyone knows about McDonald's. Okay. So the defendant, restaurant McCurry, he ran a fast food outlet which offered the Indian and other local Malaysian cuisine food. Okay. I believe it's in somewhere in Jalan Ipoh, during those days, that time. Now, see here, the defendant did not serve any kind of food available at the plaintiff's outlets. And what happened is that the plaintiff sued the defendant for passing off the plaintiff business as its own. Why? Because he pleaded that the defendant had adopted the plaintiff's distinctive, this word MC, identifier for its own F&B outlet. Okay, so in the High Court, during the High Court, the High Court judge, the trial judge, held in favor for the plaintiff. So McDonald's won in the High Court, and the judge, she held that customers familiar with McDonald's and MCD, the trademark, would logically assume that the MC in the defendant's McCurry restaurant was associated in some way to the plaintiff. So if you put an MC there, you are something like associated to McDonald's in some way. The trial judge applied the case of McIndians, which involved the registration of McIndians mark, where it was decided that it was confusingly similar to the McDonald's prefix. Okay, please bear with me for a while because looks like we have some, wait, let me check. There's something, wait, just give me 1 second. So sorry for the technical things here. Okay, just hang on. All right. Okay, so sorry for the disruptions, and let's come back to where we started, where we stopped, sorry. Okay, so so let me repeat the number 8 one, okay? The High Court judge actually applied the case of Mac Indians, where it involved the registration of the Mac Indians mark, where it was decided that it was confusingly similar to McDonald's prefix of MC, okay? So in the High Court, we know that the trial judge applied that these reported cases of Mac Indians when it comes to the decisions. Of course, the McCurry, the defendants, dissatisfied with the High Court decisions, he appealed to the Court of Appeal. And of course, the main issues to be considered in this appeal was whether the trial judge had judicially appreciated the evidence when she held that the use of the word McCurry by the defendant amounted to a passing off by it of the plaintiff's trade name to which the goodwill is attached. Okay, so this is one of the issues to be determined. Now, that the Court of Appeal judge during that time was our learned Gopal Sriram, Justice Gopal Sriram, and of course, just learned counsels from both sides, the plaintiff and defendants. We all refer to the thought of passing off. And if you want to establish the thought of passing off, you need to prove these 5 elements here. All right. So first, there must be a misrepresentation by the defendant. Second, it must be made in the course of trade. Third, it must be made to the prospective and ultimate customers or consumers. It must be calculated to injure the goodwill and reputation of the plaintiff. The plaintiff must suffer resultant damage from this, okay? So all this must be established when you want to sue somebody for passing off, all right? Passing off. So let us see what the court actually said. The Court of Appeal judge first dealt with the law of passing off, especially whether the proof of misrepresentation is required for these passing off actions. Now, the defendants, McCurry, complained that the plaintiff's submissions of this Lord Fraser's judgment in this Irvin Warnick case, because in the High Court, actually the High Court applied this Irvin Warnick case, and that's why the plaintiff he won the case in the High Court. And of course, in the Court of Appeal here, the defendant again, he argued that the plaintiff's submission of this Lord Fraser's judgment in this case could succeed without proof of misrepresentation in deciding the passing off actions. So of course, I do not agree with that. Of course, the defendant said, I do not agree with that. That's why he appealed. And come back to this Court of Appeal. The Court of Appeal judge also disagreed with it, okay? And held that the misrepresentation by the defendant of his goods and or businesses as to the plaintiff is an essential element of the thought of passing off. You see, what happened is that the plaintiff said that you don't have to prove, misrepresentation when you come to the thought of passing off, the cause of action for passing off. And this was actually what happened in this case in the High Court, during the trial judge stage. But when appeal, the judge says, no, you still have to prove misrepresentation. You still have to prove that the defendant actually misrep, the consumer, misrep everybody that, he's associated with the plaintiff and blah, blah, blah. So there must be an essential misrepresentation there. Now, the issues also to be considered by the Court of Appeal is whether the use by the defendant, the word McCurry, amounts to a passing off by it of the plaintiff's trade name to which the goodwill is attached, or the other word, if we put it this way. Did the defendant represent his business to be that of the plaintiff? Did he misrepresent himself as, like be that of the plaintiff? So this is one of the questions, the legal questions to be, to be answered in this court of appeal. Okay, first, this is the court, what the court said, okay? You need to look at the plaintiff marks, the get-up, the logo as a whole. You cannot just look at just one part element in it. So you see in this case, the plaintiff get-ups, the get-up means the mark, the logo, consists of a distinctive golden arch M, okay, the golden arch, with the words McDonald's against a red background. So this is how McDonald's logos look like. Okay, now look at the other way. On the other hand, the defendant's signboard carries the word Restaurant McCurry with lettering in white and gray on a red background. Now with pictures of a chicken giving a double thumbs up, and the wordings Malaysian's curry chicken. Okay, and thus the defendant's presentation of his business is in the style and get up which is distinctively different from that of the plaintiff. So if you look at these two logos, the judge say, well, these two logos looks very different. Okay. Now, second point is the items of the food, available at the plaintiff's outlet all carry the prefix MC. So if you go to McDonald's today, you can find Mac Burger, Mac this, Mac that, all because the title all carry MC, MC here, MC there. Okay. However, as evidence from the defendant's menu, none of the food in the defendant's restaurant carries the prefix MC. So nothing. There's no such thing as MC Roti Canai, MC Teh Tarik, MC this, MC that. No, nothing. Okay, if you look at the menu, nothing MC there. Thirdly, the type of food. Now, the court also looked at the type of food available at the plaintiff's outlet is very different compared from those served at the defendant's restaurant. Because it says that the later McCurry only serve Indian foods, okay? And the former McDonald's serve fast food. So you see the court actually look in very details, okay? Number one, number two, they look not only on your trademarks, they look at the food, the product and services available at your place, and the type of the food available at your place. And fourthly, the type of consumer or customers who will patronize McDonald's and McCurry McCurry restaurant. Now, you see the customer who actually patronize these two restaurants are very different. McCurry normally attracts the adults and the senior citizens, and while McDonald's are mainly children. Now, I don't say this. The court actually say that. Okay, the judge say that. So you see, the range of customers are also different. All right. So this is one of the factors that the court will consider when granting you any, allowing you to for this passing of actions. So what happened at the end? The Court of Appeal actually reversed the trial judge decisions. The learned trial judge applied the decisions McIndian case. Now, talking about this McIndian case, you see the trial judge, the High Court judge applied this case, McIndian case, and whereby in this case, the hearing officer found for the plaintiff, which means the McDonald's. In this case, McDonald's won, yes. But we come to this Court of Appeal, in this Court of Appeal, the court said that, you cannot take McIndian case, you cannot, you cannot overlook at the fact of this case, the facts of the case, okay? You must look at the facts of the case, is McIndian case. Why? Because in this McIndian case, they don't just serve, they don't just sell Indian food. they also sell chicken, fried chicken, cheeseburgers, French fries, shakes, which are all the very item of McDonald's are selling. So, and that's why you see the court also say that, you know, you cannot just say that, oh, because you put the MC and no one can use the MC. No, because McIndian, this case, McIndian case is different compared to McCurry. McIndian case, that guy actually also are selling, you know, were selling fried chicken, cheeseburgers, and all the list of all the item of goods which are, you know, exactly the same like McDonald's. So that's why in that case, the hearing officer found for the so-called plaintiff. All right. So you see what happened here is that the judge is trying to distinguish. Okay, he's trying very hard to distinguish that no, you cannot follow this case. All right, you should look into the facts more precisely. That's why you must appreciate the evidence more precisely. But in this case, his lordship refer to a decisions made by the Singaporean Court of Appeal in this case called Yuan Yu Kwang Frank Yuan Yu Kwang, I think, versus and McDonald's corporations, whereby in this case the Singaporean court disregard the objection of McDonald's and allowed the registration of the trademark Mac China. Okay. So why? Because in this case, the defendants actually proved that they are actually authentic Chinese restaurant. So they're not, they don't sell any items which are similar or confusingly similar or identical to McDonald's, you know, restaurant. Okay, so that's why in the Court of Appeal, the court actually allowed the registration for Mac China. Okay, let's come back to the conclusions of this case. The fact that the defendant chose the name McCurry cannot by itself lead to the inference that it sought to obtain an unfair advantage from the usage of the prefix MC. Okay, it would, you see, because he chose the word MC in front, McCurry, you cannot straight away draw a line and say that, no, this one belongs to McDonald's. No, okay? Now, the court also made an observation that it would be different if the defendant had offered its customer items that were labeled either the same or similar than to those sold by the plaintiff. So example would be like McFish or McLamb, okay? So if McCurry is selling French fries, you know, or something like a cheeseburger and all this thing, well, he might get into trouble. But in this case, the fact is that he is not, all right? So the Court of Appeals held that the trial judge had misdirected herself on the proper inferences to be drawn from the proof and admitted facts. Court of Appeal held that there's no proof of the thought of passing off in this case, and therefore appeal allowed. Okay, appeal allowed with cause. So McCurry won the case in the Court of Appeal. Someone will ask me, so did he went all the way to the federal court? No, because I think they couldn't get the leave to appeal to the federal court. So, yep. For those participants at the Zoom webinar, as I said, so sorry because we cannot have Q&A now. Okay, and if you wish to ask any questions, perhaps we have to do it some other time, or you can call us at any time during our working hours. Okay, or send me an email. Thank you. So next, this will be a bit long, okay? And then I hope I try to explain it. Okay, this case involves trademark infringement and passing off, okay? The previous case, McDonald's and McCurry's, will be just purely on passing off actions, okay? No trademark infringement. But here, in this case, the Skyward Development Sdn Bhd and Skyward Holding Sdn Bhd, and this is a very recent Court of Appeal case since last year. And this case will touch on both the trademark infringement and the law for passing off. Okay, now please allow me to explain to you, and I hope that you can understand, because it's going to be a very long one. It took me I've read this case 3 to 4 times so that I don't miss anything out. Okay, let me introduce, okay, to everybody. This is a Court of Appeal case. The plaintiff in this case is a developer called Skyver Development Sdn Bhd, okay, who is also the appellant in this case. Appellant means that in the High Court stage, he lost the case and now he appealed to the Court of Appeal. The defendant in this case will be Skyver Holding Sdn Bhd, and they are the respondent for this case. Now, there's no relations between these two companies, all right? Okay, let me ask you, let me just tell you the facts first. Now, see, this is the material facts. The plaintiff claimed that, in this case, the plaintiff claimed that Skyver is a prominent feature of the Skyver registered trademark. So the plaintiff, Skyver developers, I will call I will put in a short note as a developer. I will refer him as a developer, okay? They were in the business of real estates and property development, and they own and use the Skyver trademark since 2014. On the other hand, the first to the fourth defendants, I call them the corporate defendants, were incorporated in 2017, and they were in the business of tourism. Okay? Corporate defendants have been using the mark Skyver and Skyver in relation to their company name and the domain name, okay, as well as their purported Skyver City Sabah projects. So you see, defendant, they are not using it for the trademark logo, signage, no. They are using it for the company name, okay? For the company name, for the domain name is something like a .com internet address, and also for their projects in Sabah, a theme park, basically. They call it Skyver City Sabah projects. So the issue was whether the defendant use of the word Skyver in the name of the companies and in the name in their internet addresses, okay, domain name, and in the name of a theme park that intend to develop in Sabah, infringe the appellant registered trademark. Okay, you see, the developer had already registered a few classes of the Skyver, trademarks in few classes. All right, so we are going down, and I will try to explain. Now, it is the plaintiff case that the defendant corporate names and the website domain are infringing, okay? Infringing that they are so nearly resemble to the plaintiff trademarks, and it's likely to cause confusion in the cause, blah, 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 blah. So, of course, the plaintiff is trying to say that because you're using, my trademark in your corporate name, in domain name, you are actually infringing my trademarks, right? Okay. The plaintiff is basically, as we know, they are involved in the business of real estate development. Now they develop residential, properties in Klang Valley for sale to the public. Okay. On the other hand, the defendants are involved in the business of tourism, and they also embarking on its maiden project. They call it the Skyver City project in Sabah in East Malaysia. Okay, in this place called Karambunai. Where is it? I haven't been there, seriously. Now, from the documentary evidence produced by the defendant, the Skyver City project is a tourism theme park project. Okay, and it has been described as a universal theme park featuring replicas of landmarks, iconic buildings from countries around the globe, and visitors are able to relive their travel experience through each individual pavilions. So maybe you have the Asian pavilion, you have the Malaysian pavilion, and this pavilion, that pavilion. So this is maybe their proposal, what they're trying to do. Okay, therefore, Skyver Development, the developer, sue Skyver Holdings, okay, the Sabah projects, okay, for For what? For trademark infringement, passing off, and unlawful interferences. Now, why? Because this is due to their use of the name Skyward in the trade and business, which resemble the Skyward developments, the plaintiff registered trademark. Okay, so we know the developer is suing them. Okay. Now, in the High Court, during the High Court, okay, the High Court dismissed the appellant's claim, holding that appellant is the Skyward, the developer. The developer actually lost the case in the High Court. Number one, why? The mark used by the defendant were visually different from the plaintiff registered mark, and whatever similar that existed between these two marks was not likely to cause deception or confusions. So the High Court say these two marks are totally different. Okay, it wouldn't cause any confusions. Any similarity between the respondent marks to the registered mark was coincidental. Coincidental. All right. And appellant, the plaintiff, you had failed to prove trademark infringement under Section 38 of the Trademark Act. So this is in summary, in short and in summary, what the High Court actually said. The plaintiff's contention is that, okay, the Skyward and the Skyward marks, are the defendant's corporate name and domain name. And however, the learned judge saw that they were visually different. Okay, because the defendant's corporate name in their business document, as well as their websites, domain name, they use the word Skyward either wholly in uppercase or lowercase, but not in the mixed upper and lowercase, no, as in the the plaintiff registered mark. So you see, I'm showing you here. This is the plaintiff registered mark, Skyward. And in the High Court, the judge said that no, the defendant is using the word Skyward is either all in uppercase or all in lowercase. They don't have a mixed upper and lower like this, like a mixed upper and lowercase letter, like the plaintiff trademarks. So this is one of the reasons said why the learned just think that, oh, it's different, visually different. Okay. Now, the judge also look at the business activities of the parties. I'm talking about the High Court, okay, the trial judge, not the Court of Appeal, because this case actually went all the way to the Court of Appeal. Now, I'm going to tell you the Court of Appeal decision later, but now you need to understand the what happened in the High Court. All right, first, in the High Court, the plaintiff is basically the judge, okay, involved in the business of real estate development. The judge said that the defendants are involved in the business of tourism, Skyward City project in Sabah. And the High Court judge considered that the defendant business, that despite there are residential accommodation building planned to be built in the Skyward City project, he found that they are probably hotels to accommodate tourists, but not building for sale to the public. You see, yes, he agreed that there are buildings to be built in this tourism theme park, okay, by the defendants, but it's not for sale. He said it's for tourists, it's for like hotels, accommodation, blah blah blah. All right, so this is what the High Court, the trial judge said. So the trial judge held that prospective customers, okay, of the plaintiffs and defendants are not likely to be deceived or confused by reason of the stark difference in the business of the respective parties. And therefore, in the High Court, the plaintiff would, who are the developer, Skyward Developments, the claim was dismissed with cost 50,000 and clause. Okay, so High Court, plaintiff lost the case. You have to pay 50,000 some more plus cost plus tax or whatever. Now, okay, of course, the plaintiff are not very happy with the decisions by the High Court judge, and he appealed. On appeal, the plaintiff argued that the trial judge verdict was wrong, both in law and on facts. The appellant, who is the plaintiff as well, okay, submitted that the trial judge had not considered the facts that the respondent, being the later user of Skyward mark, had failed to prove that their adoption of the name was made in good faith and not to misrepresent. Now, this is what the plaintiff said, okay? This is one of the reasons why he appealed, right? Because he said that the respondent, being a later user of the Skyward, you fail to prove that you use the name in good faith and not to misrepresent. Okay, why? Later we tell you why. An appeal, okay? The respondent did not also explain why they chose the name Skyward for their corporate names, domain name, and theme park, and therefore it was wrong for the trial judge to conclude that any similarities of the mark used by the disputing parties was purely coincidental. Okay, when I look at the word coincidental, I cannot stop laughing. All right, but okay. Now, the defendants in this case, Skyward Holdings, he argued that in order to constitute a trademark infringement under the Trademark Act, Section 38, and this is the old act, okay, the infringement had to be used upon in relations to goods or services of the infringers. So you see here, you want to prove, according to the Section 38, you need to prove that the trademark has been used in relations to goods or services. The defendant argued that there could not be any infringement simply because an entity used a company or trade name that was identical or similar to another entity registered mark, and the usage was not in relation to goods or services. Okay? Now, the respondent, also the defendant, also submitted that the registration of their company using Skyward was valid since the ROC, the registrar of company, had allowed the registration without protest. You see, the defendant is trying to argue that, number one, ROC allowed me to use Skyward Holdings on their behalf. Okay? Secondly, because I'm using it for the company name, I'm not selling any goods or services. You see, I'm not putting on the goods or services. I'm not putting on this label. I'm not putting on the goods or services. I'm just using it for an entity, which is a company name in this nature. So you cannot be infringing, all right? And let's look at what the plaintiff counter argued. Plaintiff replied that ROC should have refused the defendant's application to register the companies using Skyward. Of course, he said, first of all, the registrar of company should have refused, okay, your registration of using Skyward for your company name. And the plaintiff also contended that just because ROC had allowed the registration of the defendants to use Skyward, I will talk about Skyward, okay, Skyward Holding, it does not mean that the appellant were precluded from bringing an infringement actions. Okay, so the plaintiff said that, hey, just because ROC allowed you to use, doesn't mean I cannot sue you, I still can sue you, for trademark infringement. Now, the plaintiff also contended that members of the public would identify the plaintiff project as Skyward, okay, without the tagline, okay, without the tagline. So if you look at this trademark here, Skyward, design the experience, well, definitely you will think of the word Skyward because this is very obvious. You wouldn't remember the whole sentence, design the experience or blah, 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 all right? Well, this is something common sense. The plaintiff also argued that the learned judge considered that the defendant business are residential accommodation buildings planned to be built in the city projects. Now, because of this, there are similarities in the defendant business and the plaintiff business. Okay, previously in the High Court, the defendant trying to say that there's no connection, no similarity between the plaintiff business and the defendant business. The plaintiff is the developer, okay? I am in the tourism, I'm building, theme park here. Okay, but when it comes to appeal, the plaintiff argued that now there are similarities because the learned judge in the trial, the trial judge in the High Court also considered that the defendant business are residential accommodations. Okay, because you build residential accommodation, so apparently the Skyward trademark, for the plaintiff also argued that there are similarities. There are similarities between these two parties, goods and services. Okay, the business, between their business and all the projects. Okay, Court of Appeal decisions. Now, before we proceed further, of course, the judge in the Court of Appeal, he took the pain to explain what are the difference between the trademarks, business name, company names, domain name. So sometimes people do ask me this, hey, Lawrence, I already registered ABC, for my company name. Do I have to register ABC's trademarks? Okay, do I have to do that? All right, do I have to, if I register a business name, ABC Enterprise, do I have to register the ABC trademarks? So let me tell you this, okay? They are all different, okay? They are all different. The trademark has their own protections, the business name and others. So let's look, I will show you the difference, okay? The court in this case are very kind enough to actually show us what are the difference between trademarks, business name, company names, and domain names. Okay, let's start with trademark registrations. Now, a registered trademark enjoys the protection of the Trademark Act 1976, but recently has been repealed to 2019, as well as the protection of general law. An unregistered trademark can be protected by general law only. So what's a trademark? A trademark is used to identify a product or service in the marketplace as to distinguish it from others' products and services. Now, of course, a registered trademark must specify types, classes of goods and services in relation to which it is used. Business name. A business name register is administered by SSM. Okay, a business name is the name that is used to identify a business, not a product, not a service. A business name is the name that the legal entity that owns the business will use to promote the business. So if I own ABC Enterprise, this business is called ABC Enterprise, and this is the legal entity for ABC Enterprise. Okay, so you need to register ABC Enterprise with the SSM. They will give you a registration, a business registration. Okay, it is possible to register a trademark that is the same as the business name, but there are different registration to achieve different objectives. Registration of a trademark is to brand a product or service. Registration as a business name is to identify the legal entity that owns the business or may have many products or services. Okay, so these are all different things. Okay, all different, yeah. Okay, company name. A company name is a company registered when the company is registered with the SSM. Okay, we call it SSM in Malaysia, Companies Commissions of Malaysia. So a company name is the name of the type of legal entity that will usually have the word Sendirian, Berhad, or at the end of the name, SDN, BHD. A company that wants to call its business something other than the company's own name must register a business name. Okay, now it is possible to register a trademark that is the same as a company name, but their different registration are to achieve, again, different objectives. Registration of a trademark is to brand a trademark, a product or services. Okay, and again, registration of a company name is to identify the legal owner of that company. So domain name again, what is the domain name? Domain name is the internet address, like your .com, google.com, yahoo.com, or maybe trademark2you.com. That is the domain name, it's internet address. It is very common for domain name to be the same, similar to a trademark, a business name, or company name. Hence, the different registration are to achieve different products. A domain, different objectives. A domain name is registered so that there is an internet address. So you register a domain name for your internet address. Okay. Now, again, I say the trademark is registered to identify a product or service. And a business name is to register to identify a business who wish to trade other with its own name. And of course, a company name is the name of a specific type of legal entity. All right. So the court actually took a trouble to distinguish. So what is the trademark? What is the company name? What is the business name? And what is the domain name? Okay. In this case. Now, I summarize some of the keynotes, key decisions held by the judge, okay, in the Court of Appeal. Okay, keynote 1. Now, in this case, the defendant say that, hey, look, there are other companies, you know, who are using the word Skyward. Okay, so in this case, the defendant actually give them a list. Look, there are so many others party using Skyward A, Skyward B, Skyward this, Skyward that. Why you don't go and sue them? So the Court of Appeal, the judge, in this Court of Appeal, the judge say, the fact that the plaintiff has not pursued action against other companies or parties using the Skyward, this word Skyward, does not preclude them from pursuing this claim against the defendants. So you see, it doesn't mean that I cannot sue the defendant. Okay, I do not have to sue others first. Okay, all right. So it's bad luck lah. So I purposely want to sue you. All right. The purpose of registering a business name is to ensure that customers and businesses are able to identify, ascertain who is the operator or actual legal owner of the business. However, the court say, registered trademark enjoys the protection of the Trademark Act as well as the protection of a general law. Okay, so there are differences here. You register a company because you want to know who is the owner. You register a trademark, okay, trademark has a protection under the Trademark Act. Okay, number 2, the learned trial judge had erred in the law as it is tried that the plaintiff in an infringement action is not required to establish that the infringing mark is identical. It would suffice if the mark is likely to deceive or cause confusions. You see, in this Skyward case, in the High Court, the judge said that, you know, the judge held that because it's not identical, they're not the same. You know, this business and the business are not the same. Then there's no infringement. In the Court of Appeal, okay, the learned judge actually agreed that, you know, with the, of course, with the plaintiff's submission that you don't have to prove that the mark is identical or something is identical. You just have to prove that it will be sufficient if the mark is likely to deceive or cause confusions. Okay, you don't have to prove that there is an actual, whatever, what they call it, actual confusions or whatever. Okay, likely or confusion will be good. So the judge also agreed with the plaintiff that the trial judge, when I say trial judge, means the High Court judge, okay, the lower court judge, should not drawn into conducting a microscopic comparison of the minute difference between the competing marks, namely whether the defendant marks are used in the upper, lower case. You see, the judge says when you want to compare a mark, you don't actually look at whether this is uppercase, lowercase, you know, all this thing. No, this is wrong. Okay, this is wrong. All right. So this is what the Court of Appeal judge said. Okay, in reverse, when you're reversing the decisions. Keynote 3: the learned trial judge in not inquiring whether the use of the infringing names or marks comes within the specification of the services covered by the Skyward registered trademark. Now, instead, the learned judge was embarking a wrong inquiry of whether the plaintiff and the defendant were engaged in the same business in determining the issue of infringement. Okay. Now, you see, what he's trying to say here is that the judge, the High Court judge, okay, he erred. That means there's an error. Okay, he made a mistake or she made a mistake. Okay, because he did not actually consider or inquire what are the services that come within the protections, within the specification protection of the registered trademark. Okay, instead, the learned trial judge, okay, ask the wrong questions. Okay, maybe they're asking the wrong question, whether you're looking into whether this defendant and the plaintiff business are in the same business when you come to deciding whether is there any trademark infringement in the case. All right. However, in the Court of Appeal, the Court of Appeal adopted a different approach when determining whether the defendant's activities come within the scope of the trademark specification. Okay. So when somebody is suing you, of course, suing you for infringement, the plaintiff would have to prove that your business activities, your goods and services are actually covered under the registered trademark classes, okay? The specific classes, all right? Now, keynote 4. The appellant has established that the legitimacy of the Skyward City project in Sabah was a suspect. So the plaintiff said that because the Sabah City project is a subject of the police investigation as a fraudulent activities, and therefore the respondent were not actually genuine trader but tortfeasors attempting to write on the appellant's goodwill in Skyward name and mark. Okay, this is what they found out later, that this whole thing called Skyward City project in Sabah, okay, owned by the Skyward Holdings, the defendant is actually under police investigation because maybe according to the court, the facts that the respondent had infringed, in this case they had infringed the registered trademark belongs to the plaintiff, because he's trying to prey on unsuspecting investors to invest in a project that was not approved by the authorities. And again, the trial judge in the High Court failed to consider this crucial evidence when they dismissed the the plaintiff's claim. Okay. Keynote 5. Next, the trial judge also failed to appreciate that the appellant had requisite goodwill in the Skyward name and mark through their extensive and substantial advertising and promotional activities and investment to establish a claim for passing off. Okay. The defendant, Skyward Holding, they also say that you have an obligation as a business newcomer to ensure that there are no confusion aroused from the use of the infringing marks and names. Okay, however, but they failed to discharge these obligations, and they were in the same field with the appellant. So you see the court say, hey, you Skyward Holdings, if you want to use the name, you have to try your best not to confuse the the consumers to believe that two of you were actually somehow related or whatever. Okay, you have the obligation, they call it, but he failed to discharge this obligation. Okay, the defendant failed to discharge these obligations. Keynote 6. Now, further, the defendant were engaged in a business that were allied. Okay, allied means relating to the appellant business. Both parties in this case were involved in real property development. Now, even though the respondent is for the tourism purposes, but both of them actually involving in property development, real property development. You develop for sale or you develop for for rental, that is also real property development. Therefore, the respondent use of the infringing name and the mark amounting to a misrepresentation. Okay, for keynote 6, don't forget, as what I mentioned earlier in McDonald's case, in order to establish a cause of actions for passing off, you need to establish there are misrepresentation. Okay, so for keynote 6, the court actually trying to analyze whether is there any misrepresentations. Is there any misrepresentation here which amounts to passing off good view? All right. So in this case, the court said that Skyward Development and Skyward Holdings were in the competition with each other, and therefore damages were readily inferred. However, the Court of Appeal held that the plaintiff in this case did not suffer any damage. Funny, you see, there's a misrepresentations, there is damages ready to be inferables. However, there's no actual resultant damage in this case. Why? Because Skyward, the plaintiff project, were actually in, mostly in KL area, all right, in West Malaysia. The defendants, the Skyward Sabah project, were in Sabah. So it's two different far side away. So the consumer would not, there's no, the plaintiff cannot prove that there are actually suffer any damages because of the misrepresentation here. All right. So again, if you couldn't prove all the elements for passing off, you cannot establish a cause of action for passing off. All right. So no, even though you have misrep, you have the same, goods or services in, consumer, whatever, but you cannot even prove resultant damage. So how can you, you cannot institute a cause of actions. Okay, you cannot succeed in bringing a cause of action for passing off. So come to the decision of the Court of Appeal. The Court of Appeal unanimously allowed the plaintiff appeal for trademark infringement. In this case, there's a trademark infringement. Yes, okay. Skyward Holding has infringed the trademark belongs to Skyward Developments. And the High Court decision set aside. Okay, right. Let's come to the last case, okay, that I want to share with you today. This is a High Court case in 2016. The plaintiff here is Mutiara Rini Sendrian Berhad, the Curve, also known as the developer of this Mutiara Damansara and the shopping mall, the Curve. The defendant in this case is the Coram View Hotel, Sendrian Berhad, previously known as the Curve Hotel Sendrian Berhad. Okay, now let me just explain, introduce to you. The plaintiff, we all know they are developers, okay? They develop shopping mall and, they have hotels, they have properties, all right? And the very famous one is the shopping mall, the Curve. And the defendants, they are the operator, business operator for the Curve, for the hotel, known as the Curve Hotel Sendrian Berhad at Bayan Baru, Pulau Pinang. Okay? So what's the material facts of this case? In this case, the plaintiff, Mutiara, okay, Rini, they apply for a summary judgment under Order 14 against the defendant for trademark infringement and the tort of passing off. So plaintiff is suing the defendant for what? Trademark infringement and passing off. Why? Because the defendant, the Coram View Hotel, formerly known as the Curve Hotel, used a mark identical with or so nearly resembling with the plaintiff registered trademark, the Curve. Now, in this case, the plaintiff already registered the Curve trademark in class 35, 36, and 43. And this was likely to deceive and causing confusions. Now, the defendant admitted using the word the Curve in the name of the defendant's hotel, the Curve Hotel Sendrian Berhad. Okay, you see, the defendant actually used the name, the Curve Hotel Sendrian Berhad. There was no dispute that the defendant had used the words the Curve as part of their hotel names, the Curve Hotel Sendrian Berhad. Okay, The infringing use of the defendant were the use of the word the curve trademark in the advertisement. For example, on the signage board, the signboards of the curve hotels, also on the hotel printed material, such as advertising, promotional materials, brochures, towers, uniforms. Imagine if I put here the curve hotels and Rembuhat, you know, everyone's wearing the same uniforms, and used in the course of the defendant's hotel business. Okay, now this guy trying to play smart lah, I would probably say. All right, and he trying to, because he knows that the curve is a very famous, everybody knows of the curve trademarks, and you know, people know about the curve. So he tried to use the curve. He tried to register a company called the Curve Hotels and Rembuhat, and he used the full name of the company name, the Curve Hotels and Rembuhat, in all the brochures, in everywhere. He tried to tell people that, hi, I'm owning the Curve Hotels and Rembuhat. Okay, okay, use it like a trademark. Now, this, according to the plaintiff, lead the public to erroneously believe that the defendant and the business hotel, the Curve Hotels and Rembuhat, was associated with the plaintiff. So by doing that, you are making the public to believe that, hey, look, people look at your company name, the Curve Hotels and Rembuhat, wow, they thought you must be owned by the big developer, okay? So, of course, when opposing to the plaintiff court applications, the defendant has raised several issues here. And he says, of course, number one, the defendant did not commit any trademark infringement nor thought of passing off. And he said that the word, the trademark curve, is a descriptive word and is not registrable. And the use of the word the curve is different from the plaintiff. The elements of trademark infringement, thought of passing off, cannot be proved, and there are disputed facts which merits a trial. Okay, so don't forget, of course, for lawyers, you can understand what I'm saying. This is a summary judgment that the plaintiff is trying to apply. Okay, so of course, they're asking for a full trial, but the court actually, okay. So this is the court findings. The defendant used a mark identical with or nearly resembling the plaintiff registered mark, the curve, and is likely to deceive and causing confusions. Now the facts clearly show that the defendant has used the trademark, the curve, without the consent of the plaintiff. By virtue of an extensive use of the plaintiff, especially in shopping mall, blah, 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 the plaintiff has acquired goodwill and reputation in their registered trademark. The use of the trademark and trade name, the curve, by the defendant had led the public to believe that the defendant business, the Curve Hotels and Rembuhat, is associated with the plaintiff. So the court held that it is not necessary to prove actual confusions, that mere proof of possibility of associations would be sufficient. So this is very straightforward. You guess, the plaintiff application is allowed with cause. Okay, so by using the name of the registered trademark of belonging to another would result, in this manner. Okay, my advice to all viewers, audience, if you have registered your company name and you have been using it for a while, it's best that you must protect and register your company name as a trademark as well. If you do not do so, if someone is doing that, you cannot stop other people from using the name as the trademarks, as the trademark. And you might get, who knows, that you might get into trouble at a later stage. So, dear viewers, please go back, okay, and register your company name as a trademark. Because some of you, I know that you couldn't bother with the company name, but you have been doing business using that name for 20 over years. So it's time that you should consider protecting the name of your own company, okay, other than products or services. Okay, now, as promised, it's 1 hour, 15 minutes. Yeah. Oh, thank you. Thank God. So wait. Now let's come to the oh, how many of you still with us today? Good, plenty. Can I have some, you know, some handshake? All right. I don't need the records for the lucky draw part.